please.
Hello, Taylor and Anna Prevention on behalf of Mr. McDaniel, who joins me at council table.
Thank you. Also here before the court is Ms. Lindsay Simmons, the agent from the Michigan Department of Corrections, who's prepared today's. Nope, she's stepping in for Mr. Saladin, who prepared today's pre-sentence investigation report. We're here today for sentencing on a charge or conviction of attempted to conceal or carry a concealed weapon. The defendant is currently in pretrial custody. Bond was revoked back on March 9th. All right, Ms. Lawrence, any amendments, corrections, or objections to make to the content of the report?
No, Your Honor.
How about you, Mr. Vento?
Thank you, Your Honor. My office did.
Oh, sorry. I do have that. I've got a mitigation report, and let me take a look. There was also an email attached to that was submitted, looks like on Wednesday. Hold on, I did not read the email because that came after I left on vacation. But the mitigation report I read the day before.
Thank you.
Mhm.
May I have an extra copy of the email we received that Wednesday night. My staff got that filed right away.
Go ahead and give it. I've already got my copy, so.
I gave a copy to the prosecutor. I'll give her a moment to review. It is for the record, it's a letter of support from the client's sister.
My notes. All right. Any other questions, Mr. Caravento, to the PSI?
To the PSI, Your Honor. I would add one minor note, and it's touched on the mitigation report, but it's not entered in the PSI. But my client reports that he found out that his girlfriend would be expecting his first child, and that child was, he found that out sometime in January of 26, so very shortly before these alleged events. I have nothing else as for corrections, comments, additions, just allocution.
Allocation in this Caravento. Thank you.
Thank you, Your Honor. My client has criminal history. We don't deny that. My client has performed poorly on probation in the past. We do not deny that. Here's what I want to emphasize. Mr. McDaniel consented to a search that day. They searched his car. No drugs were found. He has a history. We don't deny that. But we would respectfully request that the court allow release, given the fact no drugs were found, given that that is a sign towards progress and he has support in the community, namely from his sister. Still messing up 100%. But are we getting away from the drugs? The fact that none were found that day shows that we are, and that's what we want.
For a second, the recording, the computer just froze.
All right.
I don't want you to have to.
Timeout.
No. Yes.
We're back on the record again. We had a brief hiccup with our computer system for court reporting. That is now back online. So we're again taking up People versus McDaniel, and we are in the midst of Ms. Fioravento's allocution. You may continue, ma'am.
Thank you. In consideration of the snow factors here, we respectfully request that the court allow a chance at probation, or in the alternative, follow the recommendation of probation and keep the sentence within county time. Mr. McDaniels has been making, factor one as to rehabilitation, Mr. McDaniels has been making progress. He's completed his GED. He has been working on treatment. And again, I emphasize the fact that no drugs were found is evidence that that seems to be working this time. As to factor two, protection of society. While certainly this was an item that Mr. McDaniel should not have had, he was living in his car at the time. Reports he was using it to maintain and work on his vehicle, and it was not used for any violent purpose. It was not used in the commission of a felony. It was just something he should not have had on him or in his vehicle. As to factor three, punishment. I would emphasize again that the reason we have even a high guideline of 0 to 17 is the history. The OVs are all scored at 0. And then finally, third or fourth factor, deterrence. Whatever we did last time, I would emphasize it seems to be working. No drugs were found. For that reason, we would ask that Your Honor allow us to continue Mr. McDaniels on this path, give him probation, or at least give him county time. And I know this court doesn't like us bringing up kids in general when someone already has kids. What's the motive to change? This is his first child. That is his motive to change. Now, if he's back here again in the future, well, clearly that wasn't enough of a motive. But we see a significant change here. This isn't, oh, I want to be here for my kid who's 16. I've never seen them but 3 times in their life. We have someone who wants to be present, wants to be engaged. And even though he definitely had a big hiccup, and we're not denying that, we are seeing progress, and we don't want to stop that progress. Thank you.
Thank you. Ms. Lawrence, on behalf of the people, ma'am.
Thank you, Your Honor. While I do admit that there was no controlled substances found on this stop, I think it is important for the court to know that the defendant was driving a vehicle with 2 other passengers in it, and both passengers had outstanding warrants, as well as the defendant also had an outstanding warrant at this time. And one of the passengers was found to have a methamphetamine pipe inside of his rectum. So although no drugs may have been found on this stop, I do think the defendant is still surrounding himself with individuals who are involved in that type of criminal behavior. Looking at the defendant's prior record, he clearly is not a good candidate for supervision. Based off PSI, I noted in 2012, his probation was terminated unsuccessfully for multiple violations and new criminal behavior. In 2013, same thing, terminated unsuccessfully. In 2013, going into 14, he had several probation violations, including new criminal behavior, absconding, cutting off the tether, and testing positive for controlled substances and alcohol.
When was that again?
2013 and 14.
Thank you.
In 2020, he absconded while on bond for an OWI. Also in 2020, he had failure to test as well as positive tests for controlled substances while on bond, and was eventually sentenced to prison. I don't think he's a good candidate for court supervision. He does not have a history of doing well being supervised on bond or probation. I believe in this case alone, he had 3 failure to appears, if I recall correctly. So I would support the recommendation in the PSI. I do think a jail sentence is appropriate, and I would ask the court to sentence to jail. Thank you.
Thank you. All right, Mr. McDaniel, you do have a right to make a statement. Is there anything you wish to say today?
I think Mr. Bento covered it pretty well. I'd just like to say that when she said I'm expecting my first child, I grew up without a father in my life most of my life. Now that's one of my biggest fears, is not being able to be there for my child, especially in the first.
When's the child? When did you find out about?
June. I found out in the middle of January. So.
Thank you. I'm sorry, I did not mean to interrupt you and cut you off. Anything else?
No.
All right, thank you. In this instance, the court has one charge of attempt to carry a concealed weapon. Now, that was brought way down with dismissal of other charges and the reduction or dismissal of the habitual offender fourth. So out of all that, I'm sentencing you for an attempt to possess, even though you did possess it, an attempt to possess a knife. Now, were you in the midst of doing a lot of other things? Yes. Can I say that those, I can take that into consideration by preponderance of the evidence? Yes. You were living in a car, driving a car without insurance, without registration, without a license. And so, yeah, most of the stuff that you were doing were 93-day misdemeanor kind of things. It was this felony of the possession of the knife that makes it, and by the way, it's an attempt. And realistically, and it's okay, there's no way for the Department of Corrections to make this work. When you list the maximum offense, it's still technically up to 5 years. It's not up to 2.5 years. That's a prior appellate court decision that interpreted it. And I think they interpreted it incorrectly because the statute strictly says it's still a maximum of 5 years. It just goes down to a different grid, but that's okay. So I've got a handful of misdemeanors here. And an attempt to possess a knife, but you had everything else in there because that's where you were living. Yes, Ms. Firavento, she probably said it 6 times. Maybe she only needed to say it 5, but she did say it several times. There weren't any drugs in there. Now, yes, the other thing here is probably driving the prosecutor's suggestion of 10 months is because of the prior criminal history, up to no good, driving a car, all that stuff. I got it. Your criminal history and your probation history is terrible. Your bond history isn't very good. You had for a long time used controlled substances for an extensive amount of time. By the way, if it were really true that you haven't been using, but nobody pays attention to everything on these forms. Sometimes they listen to me 1 month and they forget what I said the previous month. There's no end date on CFJ 145 page 1 to show me, according to this, it actually says you still use methamphetamine and marijuana. But I understand that that's just something nobody paid attention to. It's not a big deal. And by the way, I'm not here to punish you for that. I think the prosecutor's argument, which is okay, makes sense. Looking at your criminal history, yeah, it's juvenile crimes. For instance, in 2009, the day you were discharged for MIP probation, this very same day, it looks like you picked up another charge for a retail fraud of maybe tobacco products, I guess, I don't know. And there were short gaps in time, violations of probations, things like that. So yeah, there's a lot of repetitive conduct. But in reality here, I'm looking at the possession of a knife that wasn't hidden, it wasn't being used. Yes, it was an illegal weapon. Yes, you had it in a car, but you also had underwear, socks, and clothing in the car, which are nowhere crimes. The point is, everything you had was in the car. And I don't feel, well, I will obviously take in somebody's prior criminal history as a reasonable grounds, and of course, it's used to score. This isn't a repetitive nature offense. Had you had a lot of prior weapons charges, yeah, then I'd do something. If this had been a thing where you've been brandishing it in front of other people, yeah, I might do something. Yes, it's true that you violated bond and we had because you weren't appearing or you were out there doing something. So yeah, a lot of reasons. I'm giving you a full year, easy for me to do today. But the way I look at it, other than the knife, which again wasn't being used, and it wasn't a firearm, it wasn't being brandished, and you were really committing a whole bunch of 93-day misdemeanors. Right, except for the no insurance, that's up to a year. All right, so let me find my form. Just a second. My sentence is largely driven by the fact that the defendant does have a prior criminal history and it's extensive and he's violated probation and bond so much it's hard to keep track. But then I balance against that the fact that this is largely a whole bunch of 93-day misdemeanors or 1-year misdemeanors and things like that. So the court sentences the defendant to. I'm not going to give him any probation. A $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost, a $300 attorney fee, a $500 fine. The court sentences the defendant to a jail term, finding there to be reasonable grounds based upon all the factors I've stated in that which is contained in the pre-sentence investigation report. And I sentence the defendant to, let me do some math in my head, hold on. $120 days with 54 days of credit. Got about 45 days to go. Fines and costs are due payable today. Within 56 days, failure to pay can result in an increase of a 20% penalty. Typically, I would use probation to help encourage you to keep paying. I don't think probation is appropriate here pursuant to 771.1, or is it 0.1 or 0.4? Anyways, 0.1. And also failure to pay can just get you into contempt. So I hope you get out, hope you get a job, hope you're able to pay for it. And if you are unable to pay, if you are able to pay and keep making steady payments, I almost always waive the 20% penalty. If I have to send out a subpoena for, a show cause for contempt for failure to pay, then I may not dismiss that 20% penalty. Does it make sense?
Yes, Your Honor.
Any questions?
No, Your Honor.
Thank you. All right, so anything else, Ms. Simmons?
No, Your Honor. Thank
Ms.
you.
Lawrence?
No, Your Honor.
Ms. Fiorvento is going to bring to you 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the other copy. Now, both copies of this document say exactly the same thing. It provides that you have the right to file an application for leave to appeal and not a claim for appeal by right. Furthermore, if you choose to file an application for leave to appeal and you want me to appoint an attorney to assist you, which by the way, you'll be out of jail before we even ever get to that, you may complete a copy, return to court within 42 days. Any questions, sir?
No, Your Honor.
Thank you very much. We are adjourned. Our next file is going to be People of the State of Michigan versus Christopher Perkins. This is file number 26-14211 FH.